Welcome to Frank Wealth Insights, a financial and investment podcast from Return on Life Wealth Partners. They look at your money. We look at your life at returnonlifewealth.com.
Good morning. I'm Frank Fantozzi, president and founder of Return on Life Wealth Partners. It's a great year for our firm. We've just celebrated our 30th anniversary as our team continues to grow and have fun. I'm excited to be joined by our special guest, Connie Powall, attorney and partner at Gertsburg Licata. Connie has practiced law in Ohio since 1991, assisting families, closely held business owners, and high net worth individuals with succession planning, gift strategies, and the disposition of business interests. Well, welcome, Connie.
Very nice to be here, Frank.
So what have you been up to? Got any big news? I heard there's a wedding in the future.
Yes, my daughter is getting married in Italy next year, and it's been a little bit challenging, but it is. I'm very excited about it, and I like the guy. So that's always a good thing. Yeah. So we're really excited about doing that.
What does Dad say? Has he passed the dad test?
He passed the dad test. So we've had a few come through the door that didn't pass the dad test. So this is a good one.
Yeah, good. Well, you definitely want to keep her because it's a lifelong commitment. That's exciting.
This is our third wedding. So this is our last wedding.
All right. So now you can start saving more for your finances and your own retirement, right?
Yep.
Well, we're here today to talk about estate planning, do's and don'ts, and really thoughtful planning through estate planning documents. I wanted to have you kind of talk about the basics, at least starting out, the toolkit everyone needs to be considering and why those documents are important and maybe where some people misstep. So maybe we could start with what is really estate planning in general? Because I think statistics show in our country that most people, way over 50%, don't have estate planning documents. And part of it, we think, is that people are just afraid of the whole process. And when they're afraid of doing something, they tend to keep putting it on the back burner. But maybe you can enlighten everybody as how you approach estate planning and how you communicate that to the people you take care of.
Sure. I think estate planning is very important. And I'm not just saying that because I'm a lawyer and I do this for a living. The cost to probate an estate. I always use an analogy. I'm not Frank. I'm not as good as numbers as he is, but for a normal estate that's worth about $1 million.
Okay, which is not a lot today.
Nope, not hard to get there anymore with all your retirement accounts, your house, your cars. It's very, very easy to get to $1 million. You're going to pay a lawyer about $45,000 to probate that estate.
Wow.
And that's a big chunk of change.
Yeah, it's about 4.5% of the value of the estate.
Yeah, it's dictated by statute.
Okay.
So
statute meaning the state sets the pricing.
Correct. Right. Correct. So lawyers can go in and petition the court. So that's one of the reasons why I tell people they really need to get their estate planning done. The second reason is you are now in front of a court and you're not doing this independently without court involvement if you have to probate. And I always like to explain probate. You'd be shocked how many people...
Yeah, people don't even understand what
they don't even know what that means.
Right.
Yeah. And so what it means by probate is if there's always the difference between a will and a trust. A will is simply written instructions of who's in charge and who's getting the money. The will in and of itself does not avoid probate. People think that they have a will that they've avoided probate somehow. That is not the criteria for avoiding probate. And when you say what is probate, it's the fact that you have to go to court to actually do the distribution of your assets. Even if the will says who's getting them, you still have to do that.
And people can challenge the will too. Like in contentious families, they might not like what you leave them in their will, and they can technically contest it, right?
Yep. So in our wills and our trusts, we have what's called the no contest provision.
Okay.
And what that means is if you fight, you're disowned. So
that's a way to get voted off the island.
Yeah, especially with kids. Parents have this desire to make sure their kids are going to get along forever. This is their final way of making sure that happens. They've made the decisions on how they want the distribution of their assets to go, and they do not want these kids to fight about it. And so we put that in there to kind of put them in line, keep them in line during the pendency. They still have mechanisms that they can go to arbitration, which is, outside of the courts, or mediation, which they can talk about resolving matters, but they don't end up in a huge legal battle.
It's great. Well, it saves costs there.
Mm-hmm.
Now, without a will, I mean, I can't speak to every state, but I know in Ohio, they have a succession of who gets the assets. So in the worst case scenario, and we're not advocating, again, that's why we're here, why you should have a will, potentially considering trust in your planning. Isn't there a script that the court follows that if there is no will, how do the assets get distributed?
Correct. So normally a spouse will inherit the majority of your assets, even if you have children. But if you are on a second marriage or you have children from a prior marriage, that gets a little bit more complicated. And the court goes into a distribution mechanism in reference to who gets what and how much.
Wow.
I can tell you the majority of our litigation cases that we have at the firm are because of those scenarios.
Right.
So
when we always want to avoid litigation, everyone.
Yes, that can be extremely expensive. And that's why I always tell people still doing your estate planning isn't necessarily cheap. It's not. And I'd rather probably have a new couch or go on vacation.
Right.
But the amount of money it's going to save you in the long run and the aggravation it can cause your family.
Yeah, in a sense, you're prepaying to avoid a lot of costs. But I think more importantly, it's the harmony that can happen to a family. It's amazing through all the years, and it's not just in estate planning. It happens in business if you don't have what they call a buy-sell agreement. We think of that as like the will for a business. That all of a sudden, once money gets involved, people's personalities tend to change sometimes, and it leads to very fractured families. So we feel and advocate and refer work to you because of the fact that you help families avoid all that. And yes, there's an upfront cost, but the savings in money and most importantly aggravation and harm to the family get really mitigated.
Right. And I'm here to help them. I'm not here to make their life harder. And so I've been doing this for 34 years, like you stated in the beginning, so this isn't my first rodeo. And I've been lucky enough to meet some amazing people over the years. And I honestly believe, the way you can avoid those or have problems with those is to kind of deal with them up front.
Well, I know when we talk to clients before we send them to legal counsel, we've described estate planning because they get really nervous thinking about the implications and making decisions. And a couple things we try to tell people is, one, unless you make what they call an irrevocable decision, whatever you decide today, if things change in even 6 months, you can go back and change it. The other thing is we try to create context because especially with the internet now, people look up and there's all types of legal remedies to do estate planning. And so we try to tell them, think about estate planning this way. It's taking what you have, giving it to whom you want, when you want, with any conditions. I go, if you can articulate that verbally or in writing to your legal counsel, then they can start to draft a document to reflect what you're saying. So we try to dummy it down and really focus to, making them think about those steps. And it gets away of thinking about wills and powers of attorneys and this trust and that trust, so they can communicate to you, and then with your expertise, so you can guide them as to what vehicles are needed.
Yeah. One of the things we started with the firm, and I think this is very important because I think it's very innovative and it's not your normal thing. I have had clients over the years who are afraid to call their lawyer back. They're afraid. How much is that going to cost me? What are they going to want me to do? And they don't call.
Okay.
But then unfortunately someone passes.
Right.
And they come to my door and I'm like, oh no, why didn't you call me? This could have cost X and now it's costing X, Y, and Z. You know what I mean?
Yeah.
And so I felt bad about that.
Right.
And like you, Frank, I've had clients for years. They're my friends. They're people I have gotten to know over the years. I've watched their kids grow
Right.
and all that. So we started a program what's called our Client Care Program.
Okay.
And what that does is, and once you get an estate plan, which you get your plan, whether or not it's a simple will package or if it's a trust package, doesn't matter, for $395 a year, you can come in and make any changes you want all year.
So it's like a maintenance program.
Yes, it's very
it's like servicing
similar.
your car. You take it in and get it tuned up.
And the first year you sign up, you get it for free for the first year.
Okay.
So let's say, for instance, the first time you do all your estate planning, and then it's 3 months later or 5 months later, and someone passes.
Right.
And you know how our lives go.
Oh, these major life events, right?
Yeah. And all of a sudden, the people you thought now you're not as reluctant to pick up the phone, especially in the first year, because it's free. So we give it to you for free just because we want you to understand the benefit it provides you. We also give literature and annual, like you'll be part of our newsletter, you get updates under the law, and we do a recap at the end of the year of all the legal changes that have occurred. Now, some of them might not apply to you, but some of them might be like, oh, I didn't know that. That might be something I need to think about.
Okay.
So that makes me feel better because I want my job and why we do what we do, yes, is to help people also.
Right.
And if I know I'm doing that and making them more successful and giving them some peace of mind, it gives it to me.
That's awesome. So we know a will doesn't avoid probate, and it's your basic instructions. As I kind of simplified, it's like taking what you have and telling, in a written document where you want your assets to go. What are some of the key players? Because once you pass away, you're not there to do anything. Who are some of the key people in a will and things that people need to think about?
So in a will, you'll appoint an executor. You can also have alternate executors. Let's say, for instance, you originally pick your spouse to be your first executor. Then you can have an alternate, maybe be your oldest child, be the second alternate. I think it's very important to pick the individual that would probably, once you get past your spouse, the individual will probably be the fairest and most conscious of all the people that are getting distributions. It creates a lot less aggravation and peace for the family. And so we usually have pretty lengthy talks about why they're picking and who they're picking.
Yeah, it's not an easy job. It's a very big responsibility because it does take a while to close an estate. It's not something that gets done in 30 days. So typically, if it's not a complicated estate, let's say, what is your typical time to really get through this estate?
Probably at a minimum 6 months.
Yeah.
At a minimum, the court requires, if you have to file a probate matter, that it remains open for 6 months.
Right.
So you are not closing that within
So 6 months to a year is probably your ballpark.
It's very normal.
Now, can the executor get paid? Because it is a time-consuming
Yep. They
position.
can get paid. Sometimes they take it, sometimes they don't. And the reason for that is because it is income to them.
Right.
And if they're one of the beneficiaries, and I think that's usually dictated by how complicated it is. Most people will waive their executor fees unless they are in the middle of a lawsuit or they have some issues with the property that they weren't expecting.
Okay. And what are the other, when you have children, guardianship's an important part. So why don't you give some guidelines to help people with guardianship?
One of the most important things I think for individuals today, especially younger couples, we put everything off. I mean, we really do.
Well,
everybody
life gets in the way of doing all this stuff, right?
And I'm really trying for people to be more proactive than reactive.
Right.
I don't want them to have a loss or do something and then all of a sudden start thinking about this stuff. So when you have young children, it is extremely important to make sure your guardianship designations are set up. And I think it's also important that who you thought might be the great guardians when you're younger, and then you go through the years, you might say to yourself, oh, thank God I didn't pass away.
Yeah, I know.
Or you might want to make changes throughout those periods of times based on your children, based on your relationships. And I think that's very important also. Yeah. So I think you owe it to your children to make sure that's taken care of. We've had litigation cases where it's not, especially when there's unfortunately a joint death, and it happens more than you think.
Okay.
I mean, it's not that you never think it's going to happen to your family or your loved ones, but you'll be surprised. Yeah. I've done several over the years, and it's been devastating to watch that.
Everyone thinks it happens to everyone else but you, but when it happens to you, then you've created a problem for the family. You might not be around if you're the person that passed away, but you've created a hot mess. Now, I've seen sometimes, maybe you can comment it as well, where, this person's a great guardian. I want him to raise my children, but, I'm leaving a lot of money, and I'm worried, not that they're going to do anything wrong with the money, but they're not, money savvy. And so we sometimes, see a co-guardianship, or maybe a corporate trustee coming in and managing the money, so that way the money will be there for all the needs to raise the child, but the person doesn't get taken advantage of, and all this money that the parents have left, the children get squandered, not through anything of ill will or deceit. It's just some people just aren't good with money.
Correct, and we do the same thing. I think one of the biggest things I also recommend is you usually try to give guardianship to your bloodline. So although you may love, let's say you're picking your sister and your brother-in-law, and although you may love your sister and your brother-in-law, you don't know if your sister and brother-in-law are going to stay married to forever. So as long as they're married, that's great. That's great. Have both of them named. But I usually encourage them to just name the blood relative to be the actual guardian.
Right.
So that if there ever is a divorce in the future and now you've given them both equal rights, that you're afraid that the brother-in-law is going to take the children.
Right.
And it's happened.
Yeah.
So, especially depending on the age of when you've passed, if they've had them for a long time, which it's great that they have that much love. But you don't want your family to go through that.
No, I get it. And I've seen people not do this. They name guardians, but they never tell the people, you're named as a guardian in my document.
Oh, yes.
And it's like, well, they might love you and love your kids, but they might not be in the capacity. Whether, take the financial issue off the table. You might be leaving enough money for the care of your kids, but they just don't have the emotional bandwidth to, if they have their own family and they're working, and now you add 2 more kids to their family, it might be beyond their capacity to handle that. So we often tell people, when you appoint an executor or a guardian, ask someone to be a guardian, ask them, is this something you'd be willing to do for me? Because it's an incredible ask. All of us who have had children love our children, but they know also how hard it is to raise children. So it's not a little ask. It's like saying, hey, go pick up my dry cleaning. This is a long time commitment.
Correct. We offer as part of that client care program, not that I'm trying to push it, I just want people to really appreciate what it can do or the things that can come with the benefits of it. Okay. So one of the programs, there's 2 programs, one of them is called more of an elite program. That is an agreement for us, and it's $100 more a year, but it allows us to agree to meetings with your family. Sometimes these are very difficult conversations to have. I know Frank and I know me, and we come from a long Italian families that talk about everything and everything's on the table. And it might not be hard for some of those types of families, but there are a lot of families that do not communicate or talk about these issues. And
everything's tight-lipped. Money is tight. You can't know how much I have, things like that.
Exactly. And I think that's very helpful to offer that sometimes, because you're kind of taking the onus off the parents or the individuals who don't want to necessarily have these difficult conversations.
Well, let's advance this a little bit. So you mentioned a good thing, involving the family, and I'm jumping ahead a little, but say people don't die young, which is great. We start to live our full life expectancy, and now we're starting to get aged. When do we start to really involve the children? What's your best recommendation on involving children? Because I know what we try to do as a firm, but I'm trying to get your input on that, because I think a lot of families have stuff in place, and that's great, but they never discuss with their children their estate plan. You never want your kids saying, well, why did Steve get this and Sally got that? You as parents can talk through this, but when do you start to advise parents to involve the children, and how do you guide them in the meeting?
I'm in my 50s right now. I hate to admit that.
But
I'm in my 50s. I know I sound 22, everyone, but I'm in my 50s. I don't think the 50s are too young. I think usually when you're in your 50s, your children are probably in their mid-20s and early 30s.
Yes.
And I think it's about the time that those conversations can happen, and they really understand. You're not quite there yet, maybe in having a complete transfer of your assets. We'll talk about that in a little bit, but you might not be there. But to really educate them and kind of, like you said, prepare them for that we are not going to live forever.
Right.
And these are some of the issues that you might be faced with. And so just to give them some generic knowledge. I have had a trend, believe it or not, which I'm very proud of some of my clients. They've been bringing their 20-year-olds in to sign their healthcare power of attorneys, their POAs, their...
And we're going to talk about that in a second, in more detail.
So they've been bringing them in, and they're introducing them to the process, I guess, and what benefits it can provide you. And I think that's been a wonderful thing.
Yeah, I think the key thing to take away for people is that while you can control the outcome in a sense of communication, who are you taking care of, where your assets are going to, you can do that while you're alive. So take advantage of it, because once you pass away, whatever you've left is left, and it's up to the family and the attorney to try to figure out your intentions. So the better you make this clear, the more you involve the people that are important to you. Call them your loved ones, so treat them like a loved one, and have them be part of the process. So you mentioned about, I think we're going to move on from wills a second. So one of the things we talked about earlier is try to avoid probate. I understand probate's a process of trying to honor your will if you have a will, and make sure that your will gets executed the way you would like, and that's what the court is doing. But if we want to avoid the probate process, how do you go about advising clients to do that?
There's two different ways.
Okay.
One way is a little bit simpler way. Mm-hmm. It is either designating your individual assets mm-hmm. with beneficiary designations. Mm-hmm. Some assets are easy to do that with, and some assets aren't as easy. So to give you an example, you could have a joint survivorship deed on your property, okay. which most people have, especially married couple. And so then one of those parties would die and the property automatically transfers to the surviving spouse. By
operation of law.
Yes. Now there's still things that have to be done in the county recorders. I don't want to get too technical, yes. but they're simpler, a lot simpler. What happens sometimes is, though, that occurs and then the parents do nothing after that.
Right.
They don't do the next step.
The contingent beneficiary, possibly.
Right. And so there's mechanisms under the law where we can do what's called a transfer on death deed. Mm-hmm. Those are deeds. It's almost like having a beneficiary named to your property if something happens to you. You can do it with your motor vehicles.
Yeah, I know that's relatively new. That's pretty cool.
Yes. You can do it with any of your financial accounts. Yeah. You can do it with a lot of different assets. It gets a little trickier, especially if you're anticipating the parties having issues between their children with personal property or other assets that aren't easily designated with named beneficiaries. A lot of people will have stock accounts mm-hmm. that they play with.
Correct.
And they do not necessarily have named beneficiaries on those.
Well, I know we're big advocates of having something in place. I know all the accounts here, at our firm, we have a primary beneficiary and a contingent beneficiary, because you never know if two people die at the same time, or like you said, one person passes away and the other person, because there was a life event, doesn't take the time to update. But I'd like you to cover one thing, because I know we try to explain it from a financial standpoint, but there is pro rata and per stirpes. And I think it's a pretty important designation when you have more than one person. So maybe you can explain those Greek terms to us.
Yeah, per stirpes defines that your heirs will inherit, your blood heirs will inherit. So let's say, for instance, I name my son. My mm-hmm. son has 2 children, mm-hmm. and I name my son as one of the beneficiaries under my will.
Okay.
And so he would receive a third of my estate. I have mm-hmm. 3 children. God forbid something happens and my son predeceases me.
Okay.
I want to ensure that his 1/3 share will go to my 2 grandsons. So each
it doesn't
of my
go to his spouse, though.
It will not go to his spouse. The way estate planning works is it follows the bloodline.
Okay.
Unless you make a specific designation to an individual outside of the bloodline.
Okay.
It will follow the bloodline. So it is an important designation to make sure you put that in there to allow that. The other
issue, if it's silent, it goes pro rata, correct?
Right, correct. And that means that the remaining beneficiaries will inherit that child's interest.
So then basically, inadvertently, in this case, you can disinherit your grandchildren by not having it.
Correct. Now, that has caused a tremendous amount of litigation issues that we've seen. Was the parents coerced at the last minute to change their wills mm-hmm. because there's no way they would have disowned their son's children.
Right.
And so those are issues that you really want to talk about. I don't like to overwhelm people about estate planning. I think sometimes it becomes a little overwhelming. I think you're really good at this also, Frank. It's an ability to just talk to people and really understand. We all have diverse families. We all have different issues. We all have things that happen to our families. None of us live in glass houses.
Right.
Everyone walks in initially and they're kind of reluctant until they get to meet me a little bit, but they're reluctant. Yeah, they are. They're reluctant. They're scared. They don't want to put out their dirty laundry.
Yeah, that's a fair part. I would say it's like going to the doctor's office. If you want the doctor to help you, they need to know everything about you mm-hmm. because mm-hmm. they can't give you the right advice to help heal you or whatever your condition is. Mm-hmm. It's the same thing in finance, same thing in legal. If people hold back information, in a way, the advice we give might not be as effective because we didn't have that basic fact. So knowing all the issues, because everything is we have a confidentiality clause that we do, and we are fiduciary. So your information is safe with us. It's just a matter of, I get the uncomfortableness. People, whether it's a third marriage and they come in and it's like, I got to do this again, it's third time, or I have an issue with a child that has drug-related problems, and you have, and we'll get into the some of the special trusts that we might want to consider. But those are things that people don't want to bring up, but it's important because we want to help you achieve what's important to you. We can't advocate enough, both Connie and I, that our job is to make you feel comfortable so you can talk about this in whatever way you feel comfortable saying it.
And one of the things that I've found, which I think is really important, is that I may have a doctor or an engineer or an entrepreneur sitting across from me, or a housewife, or somebody who's a mechanic, whatever it may be. I don't know how to do their jobs.
Right.
I have no idea how to do their jobs. But I can see in their face that they're not really understanding what they're doing. And so I always stop and I always say to them, because I want them to understand, it's kind of like the day you buy your first house and they put 80 pages in front of you and you're like, what am I signing?
Right.
I think it's extremely important for people to understand in layman's terms. And even if you're an extremely educated individual, you don't know everything in the world.
No.
And you need to go to people who can explain those things to you and give you the confidence, and you need to feel comfortable whether or not it's myself, another firm, or any of your lawyers, that you feel comfortable, and your financial advisors, to have those conversations.
Right. And the big thing is to leverage the team. I mean, we work closely when we have a client and we're handing off the legal side. We're working to make sure we're providing all the information that'll help make it easy for you, because we can anticipate, I think, what you need. Same thing working with a CPA firm. All these three people, especially the more complicated your situation is, they need to all be involved, because I think what happens I see with clients is when they see their CPA, they tend to want to give them information that the CPA only wants.
Correct.
But then when they talk to the attorney, well, they only feel like I'm going to give them what I think the attorney needs. But there's all this overlap, and so involving the team ensures nothing falls through the cracks.
Our firm is strictly pretty much a business transactional firm, and we represent mostly entrepreneurs and business owners. And what we found, my partner is Licata, and what we found was that their business plan wasn't speaking to their estate plan.
Yeah.
And we would have nightmares because their estate plan said one thing and their business plan said something else. And they've worked their whole life and dedicated their whole life to their businesses. And then all of a sudden, it's a mess. So we have designed a plan to really have us work together. So I've done this with Frank. I've done it with Frank and his some of his team members. Is we'll get on the phone. We just had one the other day with Danielle, and we'll get on the phone and we'll talk about, why does that work? Why does that not work for the parties?
Right.
Of course, we ask you before we call your financial advisor or your accountant, but I really think it's an important thing to do. We want to make sure there's not tax ramifications to what we're doing. We want to make sure that we're investing your investments correctly, and I think that approach has been extremely advantageous for all parties.
Yes. Yeah, it might be a little more money up front, but it saves problems down the road, which costs more money. What is it? An ounce of prevention is worth a pound of cure, right? Something along those lines. So one way of avoiding probate is putting beneficiary designations on all your accounts and properties, or assets, let's call it. But there's also a trust that can be done. So why don't we talk about the revocable trust and its power to help?
Okay, so I used to think years ago that trusts were only for the very wealthy. And I tell this story almost every time I do a consultation. So I find it very funny, but I'm a blue collar girl. I grew up in a blue collar town. My mother was a waitress. I think it's important for people to understand that about you, that not everybody has all the benefits and they have to work up to where they are in life. And I ended up thinking that, well, when I first became a lawyer, that if you did not have so much dollars, that you did not need a trust.
Right.
Well, a bunch of lawyers got together. Once the federal exemption level, which is what it means by that, is the amount of estate tax that an individual would have to pay if their estate was worth so much money. The federal estate exemption level right now is about 24 million for a married couple. Now, I have a lot of people that have become very good friends with over the years, but 98% of them, if not 99.9% of them, are not worth 24 million or more.
And that's assuming right now that the law doesn't change
Right.
and go back to 7 million, roughly about 7 million each at the end of 2025. So for now, we're going to assume that for this podcast, that the exemption is where it's at.
Right. Now we're having a new election in less than 30 days, and who knows? We all know how this climate has been. It's volatile. Who knows what's going to happen? And that's what always makes myself and Frank stay up at nights, because we need to constantly be thinking about you guys and are we adequately protecting you and your assets? So I tell people all the time, it's not that far off. So what lawyers did 10 years ago, they said, how can we make trust more advantageous for all parties, for more people? Lawyers like to make money. And so they have built in a tremendous amount of benefits in a very basic estate planning trust that is extremely important. Now, I can tell you that the range to do a trust, you guys all hear this, can range drastically by who you go to. Drastically, depending on the complexity of your assets, depending on what you do. But I cannot tell you how many people have entered my office with these beautiful, gorgeous binders with all this nice legal work, and there is not one thing in their trust.
Right.
Not one thing. They have spent
it's
$5,000,
called
$10,000,
unfunded trust, correct?
Correct. And what it means to fund your trust is not to actually liquidate your assets. You do not liquidate your assets. You retitle your assets into the trust name. So, to give you an example, let's say I own a home and the home is in Connie Powall and my husband's name is Mike Powell. Connie and Mike Powell is owners of this property. It will now just be titled Connie and Mike trustees of the trust of this property. I can still sell it. I can still do whatever I want with that property.
And you still owe the property taxes.
I still own it. Yeah, nothing goes. It still passes through my tax returns. It is not a separate entity yet. Nothing happens. And that allows me to then, God forbid, if one of us passes or we both pass, that our children will receive that property outside of probate. So it's in accordance to our trust designations. So that's extremely important. So we try to have people make sure their trusts are funded. And we do it two different ways. They can be resilient. People are very smart. We give them instructions to try to do it on their own. And if they can do it, great, with the help of their financial advisors, because I know the financial advisors and Frank are very good at this, they can get most of it done. But there's a few people who are just like, oh my gosh, I'm lost. We'll help you do that. We don't have to. We'll help you do that if you want us to. And helping and making sure that gets done, because I do not want you to spend a chunk of change to have a document that's really worth nothing.
Well, what about people that come in and, other clients have other attorneys says, well, just name, so we have a joint tenants with survivorship account, and they put as a contingent beneficiary the trust. Or let's make it easy. So, using you and your husband, you have an investment account that's in your name, and then you name the trust as the beneficiary versus putting your account and being owned by the trust. What's the nuance or the difference there?
Well, I think one of the benefits is under the Secure Act, especially if it's an IRA or it's an asset, and I don't want to get too technical, but a spouse can inherit an IRA over a lifetime. So a spouse can take an indefinite period of time after you pass to acquire those assets, the distributions. When a child now, under the Secure Act, which happened in 2017, and it's can only take it unless there's really unique circumstances, if it's a special needs child or something different.
Or it's within 10 years of each other.
10 years. Yeah. They can only take it for 10 years. And a lot of people will come in and do their children as the beneficiaries, as the contingent beneficiaries. That is a disaster, especially if your children are minors. And the reason why is because a child cannot inherit. They can inherit, but they cannot inherit outright your money until they at least reach the age of 18. So that will force us opening up a guardianship and probate court. So now we've just spent all this time trying to avoid probate, and now we're back in probate because we gave the asset directly to the children.
Right.
So we'll name the contingent beneficiary to be the trust, because the trust has mechanisms in it which allows whoever you named as the successor trustee to manage that money and to allow it to for the children and for the children's behalf, and allows it to avoid probate.
Okay.
So it's a great way to do it. The other way is, I always say, I worked my lifetime, I know Frank has, to accumulate wealth. Probably way more wealth than we had when we were in our 20s.
Yes.
I have a 35-year-old, a 29-year-old, and a 25-year-old. I can tell you my 35-year-old is a lot different than my 25-year-old. They're all awesome kids. I have no problem with any of them. They all did really well. But for them to get that wealth, most people's investment accounts are where they hold the most of their wealth.
Right, outside of having a business owner with a business,
Yeah. And to dump that kind of money at an 18-year-old and say, oh, here, you've just received a couple $100,000.
Right.
Without the correct financial advisor, without the correct mechanisms in place to kind of help control that and how they spend it, it could be gone in a year.
So what you're saying with the second benefit of revocable trust is, outside of avoiding probate, is you can do more complicated instructions in the trust, where if you do a direct beneficiary, naming your son as a direct beneficiary, though I know in our accounts we can't do anything special. You have to just name that person and they receive it. In a trust, you can put special instructions and provisions to protect the person.
Correct.
Against themselves, I guess.
Right. Yeah. And then there's a lot of things built into a revocable trust that can be built in, that deals with what you alluded to earlier about, God forbid, if one of your children have a drug addiction.
Right.
God forbid they're in a horrible marriage. What if you've named somebody? I always feel so bad for my daughter, but I use this as an example. Me, my husband, and my daughter in a car together. We get in a car accident. Me and my husband perish, and my daughter is now a paraplegic.
Right.
My poor daughter, but she's a paraplegic.
Why are you using me, Mom, in this example?
Yeah, but she can't inherit my money without having a special needs trust, because she will be cut off of government benefits because she has too much money. Now, having the government benefits with the severity of her injuries may be more important than to inherit a sum of money, even if the sum of money is a decent amount. That doesn't mean she can't use that money for her care. We can pay for a ramp to her house. We can buy her a special van. We can do these things, but it will not cut up her ability to receive Medicaid or benefits that she may now need. So those are built into the trust. So it's all these little nuances that help protect people from circumstances, and they sound far-fetched, but they're really not.
No, well, you mentioned divorce. I mean, one of the things, I have two daughters, and they're not nowhere near even being engaged, but we want to make sure that if they find the person they love and want to spend their life with, they inherit money from us. We want to take care of the family. But we know statistically in the U.S., basically half of all marriages fail. So my wife and I clearly don't, as hard as we've worked, do not want our monies to go to the ex-spouse. So the trust allows, because once you pass away, the revocable trust becomes irrevocable.
Correct.
And so now the idea is that the monies in the trust can benefit my daughter and her family, but if there's a divorce, correct me if I'm wrong, I can exclude the assets from the marital estate.
Correct. And you can allow for that distribution not to occur, or it can occur on need. But so then those assets are not counted as part of her net worth at that time. And so that the spouse, or soon-to-be ex-spouse, doesn't take advantage of that.
Right.
And even if it's a child support issue, like let's say, for instance, they're already divorced.
Okay.
And now they're saying, well, there's been a windfall, or there's this amount of money she receives on a regular basis from a trust estate, and they want to count that. Right. And it's like, what the heck? So for us, it's a way of kind of saying, does she need it? When does she need it? How can we distribute it? And when you're appointing individuals, just like we talked about with the successor executor, you're going to have successor trustees. It's extremely important under a trust. to have those individuals that you appoint to help whoever, even if you appoint, let's say you appoint your son.
Okay.
My son currently is in IT. He's my oldest.
Right.
I would probably appoint him. But my son does not have a financial background. My son does not have a legal background.
Mm-hmm.
He's probably heard me talk too much, but
yeah, I get it.
but he has little knowledge. But my point is we built into the trust what's called trust advisors. Correct. That he can go to. We can name Frank as our trust advisor, and he knows automatically that he can pick up the phone and go to Frank and say, help me. And Frank helps my son Jake keep in line with what he knows from dealing business with us for all these years on what our intentions overall were. So it really does help.
Yeah, and it's a big ask. One of the things I have to contemplate, because I'm updating my executor and the trustees, because now my kids are in their 20s. Well, one's 30. And while my daughter's very bright, I don't know if I want to put her in the burden of being the executor of the state. I know she has the capacity, but I might want to have a third party deal with it and pay that third party so that both my daughters can just, relax a little bit. I mean, it's because it is a big ask on the executor side.
I want to hit on one something before you move on. What you were referring to is either a third party, say an aunt or uncle or someone, but also there's something called a corporate trustee. Correct. And you can appoint a bank or someone to act in that capacity. But I can tell you when you do that, a corporate trustee, that trust needs to be drafted correctly. Like it needs to have specific language, because these corporate trustees, which could be Key Bank, which could be National City Bank.
I know we use private trust here in Cleveland a lot.
Yes, I use private trust also. So what happens is that they need guidance.
If it's a gray area, they're not going to opine to it. You got to be, like you said, you have to be very diligent about how you write out everything.
Right. So I'll give you an example really quick. I had an individual who loved their animals and left a stipend to anybody who would agree to take care of their animals of, like, let's just say $15,000 a year. Okay. They were given $15,000 a year to care for their animals, and we had a corporate trustee, and the trustee is like, I'm not touching that. I don't want to have anything to do with the animals. So we'll build in language, in that case we did, of having a special trustee for the animal clause. Right. Because we know that these corporate trustees are not going to deal with that. Yeah. So it's little nuances that we build in to help people and their wishes be found.
You raise a good point. I mean, a lot of people treat their animals like family, especially if they don't even have children. And so they do leave money for the care and create trust just to take care of their sacred pets.
They do.
Why don't we discuss powers of attorney? Because I think that's another important part of the basic toolkit. And there's a financial power of attorney, or what they call a general power of attorney, and then there's the medical power of attorney. And what thought process should go into naming those people? How does it work? How does it not work when someone passes away who gives the power of attorney? So maybe you could touch on some of that, because I think that's an important part as well.
It's very important. So let me start with the medical ones, because I can get through that pretty quickly.
Sure.
There's a healthcare power of attorney and a living will. Okay. And I always say, I don't know why the state of Ohio named everything similar, because people are like, I have a living will. Isn't that my will? It is not. It is not. A living will is not a will. A will is a will. Yes. I don't know why they made it so complicated. But the living will is when you're dying and 2 or more doctors have determined that you are not going to survive. You're either brain dead or whatever. And they will look to someone to make that decision within that legal document on who's supposed to make that decision. So I'll use Frank for a second. God forbid, let's say Frank's wife predeceases him. Frank has 2 beautiful daughters. They're standing there at their dad's bedside. Who are they going to pick? Right. Who has the authority? Nobody knows. It happened in my own family. Yeah. Nobody knows. You know what I mean? So either with my father, they said, well, he made the decision. And I said, he can't even hold up his head. Yeah. How did he make the decision? You know what I mean? So for me, that's extremely important to name it. And that agreement is an agreement between you and your loved ones. Right. It is not an agreement between you and the hospital. Sometimes people don't understand that. But what I mean by that is that a hospital can't come in and override your family. Right. In very, very, very rare circumstances, they probably could. But I can tell you, they're going to do what the family wants. Right. So it's important to kind of, again, relieve that decision making in the order in which you would like to decide that. And I think it's important because I have 3 children. One of my children is in the medical field. So she's not the oldest. So it might make sense to name her as my medical power of attorney because she has more knowledge about that.
Right.
So,
but the living will, I thought, also allows, to take the hard decisions away, saying, I don't want any heroic measures. So if I code out, they're not allowed to jump on my chest, start pounding on it, and put the paddles to revive me. I'm just going to say, hey, just let me go.
It's reassurance to the family. Nobody ever wants to see their loved one die. But it's reassurance to the family that this was your intention and not somebody else making that decision. So you've made it easy for them. So a living will is when you're dying. A healthcare power of attorney is when you're not terminal, but you're unable to make your own healthcare decisions. COVID was a huge example of this. People ended up in the hospitals and they were on ventilators or they were doing things and they didn't know who to ask. If you did not have, they'll ask your spouse if you happen to be married, but if you're not married or you have a significant other and you might have been with that significant other for 27 years, they don't know that and they're not going to go to that significant other, which is devastating. So it's extremely important to allow your family to know who you want named and how you want them. Now, a power of attorney sounds very much like a healthcare power of attorney, but it's a power of attorney. I call it a financial power of attorney. Has really evolved I believe has evolved over the last probably 10 years. And
I want to stop back. One thing I want to ask about the medical, one of the things, because people are living longer and there's more and more cases of, and dementia is the global term. It could be Alzheimer's, Lewy body, and all that. Having a medical power of attorney is really helpful as your parents age to be able to step in and help coordinate care, help your parents make decisions about their medical care when they get into an older state and things get more confusing and harder because they're just aging. So.
And we know that from just attending their doctor's appointments. And the doctor feel confident in talking to you or letting you be in the room. And with HIPAA now, we have a HIPAA waiver for even mental health issues that we include. So we have them sign all those documents so that it makes it easier for the family to communicate. So the financial power of attorney has really evolved. And there has been a push by a lot of different entities to include very specific language in your power of attorneys. One of the things I want everybody to understand, even if you have a power of attorney, Frank is great. He's doing great. He's of sound mind. He's doing wonderful. He could still have a power of attorney. What he does not need to do is when you are unable to make your decisions yourself, he can then step aside or say, I'm going to allow that individual to make it. Or he's saying, you can tell he can't make it. So you can have it before you need it. I guess my point is. You can change that document at any time. If you appoint somebody and you don't feel comfortable with who you've appointed, you can revoke that power of attorney at any time. You can have alternates on that power of attorney. But we've really gotten specific on what their powers are under those powers.
You don't have to throw everything in there. You can limit the power of attorney, to specific things they're allowed to do, and you can add and change and modify it as often as you feel fit.
Correct. And we've been very specific on specific language. Case laws coming out left and right about it not having, lawsuits are on words like may and can or must or whatever, and it's crazy that we're fighting that lawsuits can fight over those words, but they really can't. So we are very specific on powers. We go over that very detailed with you so you understand what powers you're giving your loved one and whether or not you feel comfortable giving. Some of them you give right off and some of them you don't. You say, I want to wait, and that's fine. And because you can modify it at any point, it's easily to modify. But where it's most important is kind of what Frank alluded to. Most people, they think they're going to be competent forever, or they think they're going to be able to make these decisions themselves forever. Well, dementia sets in, or Alzheimer's, just normal, and those safeguards are in place. If you fail to have a power of attorney, the only way to make those decisions for your loved one is you're in probate court getting a guardianship.
And that's hard.
And that's really hard. And so These are just ways to make things a little bit easier for people.
Yeah.
So they can get some things accomplished. And when you're going through a difficult time anyways with your parents, it's nice to know that that's there.
Yeah. Well, we're big advocates as soon as your children become 18.
Mm-hmm.
I mean, a lot of children are waiting to get married now, so they're well into their 20s, and I have a daughter that's 30. We have medical and powers of attorney with them because they're in a position, and the way I always describe it is I ask my daughter, I go, if something happens to you and you need our help, because you're over 18, I just can't step in like Superman and help you. So if you allow me to do this, I can step in and help you, whether it's a medical or financial decision. The one thing I also include is the FERPA language so that they waive their FERPA right, because if they go to college, there's protection about getting access to their school records and stuff.
Yep.
So, but we're real proponents when your kids go off to school and they're 18, please consider getting powers of attorney, medical and financial, especially the medical, because kids get hurt on campus and you want to help as a parent and you forget. I used to, a year ago at 17, you could step in and do something. Now they're 18 and now HIPAA and everything else gets in the way.
Nope,
So,
you can find out your kid. I know a couple who their son got sick and they couldn't reach him for 3 days. He had gone into the urgent care and they admitted him. And he ended up fine, but they didn't even know where he was.
Wow, that's scary.
And they don't have to call you.
Oh, wow.
You know what I mean? So the more protections you can have, the better you are.
Well, with the few minutes we have left, is there anything parting? We kind of covered today the basic toolkits of estate planning, the revocable trust, the wills, the powers of attorney. We touched on if you have special conditions, special needs trusts, and things like that. And we'll do another segment where we get into more advanced issues. But is there any little parting shots you want to pass on that we didn't cover in what I call the basic 101?
No, I think
discussion?
we already stated this, but I think it's really important that you owe yourself to do this and your loved ones. We all work really hard, and this is a generation that I believe has worked very hard. And I think that doing these things can be very helpful.
It's like legal insurance.
Yes, and that's I say it's like buying insurance early. And I think that Frank works really hard to make make money. I mean, he does, and we want to just protect that for you. And we want to make sure that it goes in your pocket or your children's pocket and not IRS or not someone else.
Yeah, an ex-spouse.
Yes, an ex-spouse or somebody who's going to just squander it.
Right.
Or creditors. One
Yes.
of the biggest things under trust, we can protect your children from their own creditors.
Right.
So those are really important aspects. Now, I'll just allude to there is way more complicated trust. There's a lot more complicated trust that we can get into, which are called irrevocable trusts, Medicaid trusts, all different things that we can use. Second marriages have a lot of times what we'll do a Q-tip trust
blended
or
families.
something. Blended families, and there is a lot of blended families. And a lot of my litigation runs from that. So you really need to protect that and everything you've done over the years. And then your business too. One of the other things is people spent their whole life in their businesses.
Right.
And maybe they're the sole proprietor or a single member LLC or the only individual, and they don't really have a succession plan. And even if they have a succession plan where that business is going to go to, who's going to do from the day you pass to the day we can get that succession plan in place? Who's going to run that business?
Right.
Who's going to sign the paychecks? Who's going to do whatever? So in one of our trusts, we do what's called an advisory board, where we put people in place that will make sure. I had one case where the asset was it was a business entity. It went from approximately a $3 million asset to like $250,000.
Right.
Because they had never done anything.
Yeah.
Nobody was selling. Nobody was doing anything to keep that company viable.
Yeah, because the owner passed and he was the engine, unfortunately.
He was the engine. So we've all worked too hard, and I know that was not his intention.
Yeah.
You know in the long run that he didn't work that hard. That couldn't have been his intention.
No, for sure. Well, thank you, Connie, for being here, helping out. So it was a lot of fun talking. And a closing note, please, when you have a life event, birth of a child, a death, even a promotion, you move to another state, those are really good times to make sure you meet with your legal counsel to make sure everything is tight and working. If you don't think you've had a life event in a couple of years, for me, I feel like I have a life event every year. Yeah. But if a couple of years go by, I would say every 3 years you should at least sit down, pull out the document, review it, sit down with your attorney and say, hey, here's how I'm feeling. Is this still being reflected in my document? If it is, great. If not, then you make the adjustments. You have the power to do this. This is not like the 10 Commandments that are written in stone and it can never change. You have the ability to affect that change. So thank you for joining me. Remember to like.
Pleasure.
Yeah, thank you, Connie. And congratulations. Look forward to that destination wedding that you're having. Yeah. That's awesome. But remember to like and subscribe to Frank Wealth Insights podcast on your favorite platform. If you have any questions about estate planning or other financial concerns, feel free to reach out to us at 877-514-9991 or visit us at returnonlifewealth.com. Connie, do you want to give your phone number?
Sure. My name is Connie Powell, like you've heard, and I work for a firm called Gertsburg Licata, and the phone number is 216-573-6000. And as part of a little promotional thing, if you guys do end up calling, I can probably give what's called our family and friends discount to anybody who calls and wants to enter into some type of an estate planning package or do something, whether or not it's a simple will package or a trust package, for just listening to Frank and this great relationship that we have. So it was a pleasure.
Thank you. Thank you again, Connie. Wishing everyone who's listening health, happiness, and a life well lived. Thank you for joining us.
This has been Frank Wealth Insights, the financial and investment podcast from Return on Life Wealth Partners. Your life, your money, your way. Experience financial planning the way it should be, not the way they want it. See how at returnonlifewealth.com. This information is not intended to be a substitute for specific individualized tax advice. We suggest that you discuss your specific tax situation with a qualified tax advisor. The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. This communication expresses the views and opinions of the participants as of the date it was recorded or indicated, and such views are subject to change without notice. This podcast is being made available for educational purposes only and should not be confused for any other purpose. The information contained herein does not constitute and should not be construed as an offering of advisory services or an offer to sell or solicitation to buy any securities or related financial instruments in any jurisdiction. This podcast may discuss forward-looking statements that are based on then-current beliefs of the participants. Investment advice offered through Planned Financial Services, a registered investment advisor.